The first case, and the only case that we heard this morning, is Bernice Claar et al. Versus Kristine Scalise. As the appellant, you have your 15 minutes in which to argue the case. He's not here today to argue, so we are being visually audibly recorded to be posted online, so please try to remain behind the podium as much as possible. And we've read your brief, so we're ready to proceed when you are.
Okay, thank you. Good morning.
Good morning.
Appreciate your time. I don't believe I need 15 minutes. It's a simple issue. Just to paraphrase the timeline, the sheriff's sale was on 8/29/17. My client, KMA, was the successful bidder. As the court is aware, bidding on a property does not make you, put you on the electronic docket for service. That doesn't excuse the behavior. It's just an issue that we were not getting notification of, like when the confirmation order came out. The confirmation order was issued on 9/21/17. There were communications with the sheriff's office, and there's evidence of that. Immediately after the sale, the individual that went to bid, who was working for KMA, contacted the office, realized a mistake was made, went back to whoever was conducting the sale and asked to have it canceled, and they said, we can't do that. There were then conversations with the clerk's office at the sheriff's office and counsel Milton Rankins just to try to resolve it. No obligation for them to resolve it. I just wanted to make it aware that there was efforts made, and the reason for that is, it's always a good idea to try to avoid litigation and try to resolve things. KMA, or the owners of KMA, buy a lot of properties in Akron and rehab a lot of properties and deal with the tax board a lot, and they pay a lot of taxes. I think they felt probably more comfortable than they should have that they could work this out without resulting to hiring me and pursuing filing the motion to vacate. The record Exhibit B reflects from the court the conversations that the owner of KMA was having, saying we bought the wrong property. So it's not like this is being made up 3 months later. The motion to vacate, those communications were on 10/17/17 as reflected in Exhibit B to the motion to vacate. The motion was actually filed 30 days later on 11/16, which was about 56 days after the confirmation order. The main issue that I have with the order is that I believe that Judge O'Brien thought the standard was that once a confirmation order is issued, that there has to be a showing of fraud or bad faith conduct in order for there to be an order to vacate. And I think her order makes it clear that that is the standard she followed. And so I believe we have on the record a case that inaccurately quotes the law. The case is cited in the order, Trans-Ohio versus Milan and EMC Mortgage Corp. v. Pratt. I just wanted to address briefly. The court quotes correctly that in the Trans-Ohio case it says that there's a strong public policy opposing vacated orders after confirmation. But if you look at that case, Trans-Ohio versus Milan, it is really paraphrasing Kavas v. Berry. And Kavas v. Berry says that with respect to a judicial sale, confirmation to an innocent purchaser shall not be set aside on the basis of inadequacy of price, absent fraud, irregularity, or bad faith. There is a difference if there's a third party that bids, they've been the successful bidder, they've taken over the property, they're rehabbing it or moving in or whatever they're doing, and then the mortgagee or party that lost the house in foreclosure comes forward and says, hey, wait a minute, there was a mistake or fraud, and I went out and do this. That would dramatically impact an innocent third party. And most of the cases that are cited in the brief by the appellee are situations where it's either the bank or the mortgagee who lost the home in foreclosure that are challenging the order. And so I believe we're taking a quote that applies to a situation where we've got an innocent purchaser and dealing with, it specifically says the inadequacy of the price, and then just applying it across the board where you always need to show fraud or irregularity or bad faith to vacate a confirmation order after the confirmation order has been issued. The other case relied upon by Judge O'Brien was the EMC Mortgage versus Pratt, and the court quotes, after confirmation has occurred, the court must find good cause to vacate the confirmation of the order. When considering the information presented, no evidence of fraud, irregularity, or bad faith has been presented. So that the court really did not consider the basis of the motion, which was a mistake, the affidavit, which was the employee saying they went to the sale and bid on the wrong house, and that's why I believe that the mistake was made.
Counsel, I'm sorry for interrupting you. I was just wondering though, because it was a little confusing as to what really was the right property, because evidently there's discrepancy of which was the wrong property, which was the right property, and so forth as well.
Yeah, and I actually did not, I read that part. I did not go back and look and sort that out. I didn't realize it was an issue. It's not before the record. I don't know what the property, I think the affidavit says it was northeast, not southeast. It's been on the wrong one, and I'm not sure if it was 325 or 326. And all I would say to the court is that, if when the motion to vacate was filed, there was no opposition to it. If that would have been brought up, that would have, could have been addressed at the trial court level as to whether. So I don't have the actual details.
That's all right. Thank you.
Okay. With respect to EMC Mortgage v. Pratt, which is the other case that the lower court relied on, that case actually exemplifies that there is no different standard before or after the confirmation order is issued. That case did not mention that at all. And EMC Mortgage actually was, I believe, the only case where the challenge was made by the bidder. And what that court said basically was that that 4.5 months was not reasonable under the circumstances in that case. It did deal with price. The bidder claimed after the fact that they were not aware that they had to pay back taxes on the property. And they tried to vacate. The court simply said 4.5 months is, even though it's within the year, the statutory rule, that was unreasonable. I would just suggest that, the difference between about 7 weeks and 4.5 months is significant. I would agree the motion could have been brought sooner. The reason it wasn't genuinely was just trying to work it out rather than resorting to litigation. I just wanted to point to another example, a case that was cited by the appellee to confirm that the wrong standard was cited, which is the Society Bank versus Wolf case. In that case, there was a confirmation order on 11/21/89. There was a motion to vacate filed on 3/21/90, much later than in this case. And that court basically said that there was a mistake made and they vacated the confirmation order 4 months after the fact based on a mistake. There's no reference, again, to a different standard that applies before and after the confirmation order is issued. I did not see any distinction in the standard in any of the cases I looked at. I admit I tried to read thoroughly all of them. There's a lot of case law cited in appellee's brief, so I could be wrong, but I don't believe there's a single case before the panel that indicates there's a different standard before and after the confirmation order. And I believe if the lower court, considering the fact that there was evidence of mistake, there was no opposition to the motion, that the only reason they granted the motion to vacate was because they believed there had to be a presentation of evidence of fraud in order to vacate the order, and because that was not submitted, it wasn't the basis for the motion, that's why the court denied the motion to vacate. That's all I have. Thank you.
Thank you for your presentation today, sir. The court will take the matter under advisement and issue a written decision which will be mailed to you as well as the opposing party, and will also post it to our website and out of the Supreme Court.
Okay, have a nice day.
And the court's adjourned until